Jurisprudence to handle litigation is always a interesting facet for any student of law or a lawyer as such. And as they say that taxing as well as the field of GST itself is quite taxing. But how do you handle such litigations is one of the topics for today, which we are taking in two parts with Advocate Vinay Shraff, who is otherwise also a chartered accountant, but he is primarily practicing. And his field towards the indirect taxation, he has created his own niche. And he's also started one series with which is also available on the YouTube. We had requested him to share his knowledge. And this particular session we will be taking up in two parts. I'll request Mr. Vinay to tell as to how this parts will be divided. Over to you, Vinay. And thank you to all those participants who are watching us live on the YouTube, as well as on this Zoom meeting. Over to you.
Thank you, Vikas ji. I'm really grateful to you for giving me this opportunity. So I will just give a brief introduction of what I intend to discuss. Can you allow me to share the PPT, please? Yes. So I just want to give a brief background of or introduction of what I wish to discuss over another, say, next 2 or 3 sessions. GST, we all know, is a amalgamation of the erstwhile indirect tax, various tax laws, like Central Excise Act, Central Sales Tax Act, Value Added Tax Act, Service Tax Act. So a lot of jurisprudence is hidden in the erstwhile regime, which is going to be very, very useful to handle the litigation which is going to arise in the future in the GST era. As of now, the litigation which is there in the GST era has all been artificial intelligence based, wherein through the analysis of the data, the department is able to unearth some evasion of tax through fraudulent means. But the litigation which arises out of the audit, wherein you see a lot of litigation arises around the interpretation of the law. So those litigation has not yet arose. They are going to arise very soon because now the audit has started, and a large amount of notices have already been issued. And in future, another, say, 6 months or so, I expect that further notices will be issued, and a lot of litigation will revolve around the interpretation of the law and not with respect to the evasion which arises out of the fraudulent conduct of the parties. So in these 2 or 3 sessions, my focus would be on discussing or analyzing the very fundamental principles with respect to levy of GST, so that whatever disputes or litigation which is going to arise out of the fundamentals of the GST law, we learn and we decode and we handle the litigation which is going to arise in the future. In a tax law, there are 3 essentials. There are 3 fundamental essential in order to levy a tax. First of all, there must be a charging section and a taxable event. And any activity, in order to be chargeable to tax, must satisfy the definition of the taxable event. Secondly, there must be computation provisions in order to enable the computation of the taxable value, because GST is a levy on a transaction to transaction. So we must be able to ascertain the taxable value of a transaction in order to levy tax. Third, we must apply the taxable value to the rate of tax. And in order to determine the rate of tax, it is necessary that the goods are classified in the proper chapter heading, because in the GST, the classification is dependent on the harmonized system of nomenclature. Each and every item of goods is classified under 98 chapters, and under those chapters there are further heading and subheadings. So one has to look into the heading and try to ascertain what is the item and where, under which chapter heading it falls. And once you ascertain the chapter heading, only then you can determine what is the rate applicable to that chapter heading. We'll go into the discussion of classification in the next session. Today, we are going to analyze and discuss the very fundamental of the levy of tax, which is supply of goods. The GST is leviable on any supply of goods. So the taxable event in the GST era is supply of goods. In the service tax regime, it was provision of service. In the sales tax or the VAT, it was sale of goods. In central excise, it was manufacture. So now all these laws have been amalgamated, and now we have a single taxable event, which is called supply. So now let us have a look at what is the supply of goods and what are the various facets of the definition of supply. And we are going to dissect the various aspects of the definition of supply, and I will be discussing the various disputes which may arise out of the very fundamental concept of supply or the taxable event. So Section 7(1) Clause A of the GST Act provides that the supply means all forms of supply of goods or services, such as sale, transfer, barter, exchange, license, rental, lease, or disposal. So we are going to discuss the various aspects of this particular part of the supply, that is, what is the meaning of the sale, transfer, barter, exchange, or disposal at one place. And then we are going to discuss the other aspect, which is license, rental, and lease. Further, we are going to also analyze the meaning of the word consideration, and also what is the meaning of in the course or furtherance of business. Because a sale, transfer, or barter, it should be made or agreed to be made for a consideration, and then it should be in the course or furtherance of the business. So it is very essential for us to know three things: that what is the meaning of the goods or service, what is the meaning of sale, transfer, barter, exchange, lease, or disposal, then, and what is the meaning of the in the course or furtherance of business. So we are going to today focus our discussion on these aspects of the taxable event that is called supply. Now, the sale of goods is not defined in the GST Act, but in the common law or in the Sale of Goods Act, one of the very essential ingredient of sale of goods that it should be between two parties by virtue of an agreement, and it should result into transfer of title in the property of the goods. So this is very, very important, that the contract is entered into for the purpose of transfer of title in the goods. Even in the case of disposal, it should result into transfer of title in the goods to other person. So suppose the goods are just thrown away and disposed just like that, disposed as a say scrap or any waste material which does not fetch any value or consideration, and it is the title is not transferred to another person, then it would not result into a taxable event of supply. Similarly, in the case of a exchange also, it must result into transfer in the property in the goods to another person. In the exchange or the barter, it may be that there is no there is a exchange of the goods or services. There is no consideration passed on in form of the money, but nevertheless there is a transfer of property from one person to another. Similarly, in the case of transfer also, it is necessary that there is a transfer of title in the property in the goods. Now the transfer may be a compulsory acquisition by the government also, but even then it will fall within the definition of the supply and be chargeable to tax. Now, another important aspect or the facet of the definition of supply is goods. So it is essential for us to understand what is the meaning of the goods and what sort of dispute which may arise around the definition or the meaning of the goods, and what sort of dispute had arose in the past in the erstwhile era of indirect taxation. So first of all, let us look at the meaning of the goods. It says that it means every kind of movable property other than money and securities, but it includes actionable claim, growing crops, grass and things attached to or forming part of the land, which is agreed to be severed before supply or under a contract of supply. So first fundamental concept is that every movable property other than money and securities is goods. So one may ask a question whether even the intangible things, for example, software, or say these scripts, various types of scripts which are issued within the purview of foreign trade policies, which are freely transferable, whether they satisfy the definition of the goods. So in this context, there have been various judgments of the Supreme Court and High Court in the context of sale tax, service tax, and central excise. And in one such case, the Honorable Supreme Court stated that in order for a property to become the goods, it is enough if it has the attributes of utility, it is capable of being bought and sold, and capable of being transferred, delivered, stored, and possessed. So if these conditions are satisfied, then it will be considered as goods. It is immaterial whether it is incorporeal, corporeal, tangible, or intangible. As long as they are deliverable and they are being capable of being transferred, they have some utility and they are capable of being bought and sold, it will fall within the purview of the definition of goods. Then there have been various judgments with respect to various intangible items to be considered as goods. For example, copyright, sale of a copyright has been considered to be goods and therefore exigible to sales tax. Then technical drawings have also been considered to be goods. Transfer of right to use trademark has been considered to be goods. Master copies of films and songs have been considered to be goods. Then DPP licenses, which are issued under the foreign trade policy, they have been considered to be goods. So all these, you see, examples I've cited because many a times there is a sale of these intangible items, and one wonders whether they fall within the definition of the goods and whether they are services or what, and whether should they are at all liable to tax in the first place. So we already have the jurisprudence in the erstwhile era, which says that all these items, whether it is a software or copyright and all these things, even though they are intangibles, they very much satisfy the definition of the goods. Another gray area which often arises and leads to some sort of a dispute, and which we will further discuss as to how and why it is important to understand this particular concept, is plant and machinery. Many times plant and machinery are embedded to the earth. So the question arises is whether they are immovable property or whether they are goods. Because obviously, if there is a transaction of sale of an immovable property, then it does not fall within the purview of the goods and services tax. Only if there is a transaction of sale of goods or services, only then it falls within the purview of the exigibility of GST. Otherwise not. So there may be a situation where you see a plant and machinery is assembled and attached to the earth. And if it is attached to the earth, then there are tests which have been laid down by the Supreme Court time to time, and which says that if the attachment to the earth leads to a permanency and it cannot be detached from the earth to which it is attached or the foundation to which it is attached without demolition or damage, then it should be considered as immovable property. But if it is attached to the earth by merely nut and bolts in order to ensure a wobble-free operation, then it does not assume the character of a immovable property. So it is very important for us to understand this concept in the various contexts which I am going to discuss further, that whether a installation of plant or machinery leads to immovable property or whether it is considered to be goods. Now, one of the questions which arises is whether, if suppose there is a sale of business itself along with all the plant and machinery, stock and everything, then whether such a sale of business itself, suppose there are say various divisions or units of a company. One is manufacturing say chemicals, one is manufacturing textile, one is manufacturing cement, or say one of the business is hived off and one of the unit is transferred lock, stock and barrel, which is called a lump sum sale, slum sale rather in the context of the Income Tax Act, whether it can be considered to be liable to GST in the purview of the and covered within the purview of the goods in the first place. Because first of all, it must satisfy the definition of the goods. So if the whole of the business is transferred, whether it can satisfy the definition of the goods or whether it can be called a service in the first place. So there have been judgments of the Supreme Court which says that if the whole of the business is transferred along with the plant and machinery embedded to the earth, and such transfer takes place through a conveyance, then it will be it cannot be said that there is a sale of goods. It is nothing but the transaction of in totality, where the entire plant and machinery which has a character of immovable property is sold along with say stock and everything. And if such a transactions takes place, then it cannot be said that there is a sale of goods. So since it does not satisfy the definition of goods itself, so it cannot be chargeable to GST in the it cannot, and therefore it cannot satisfy the definition of supply, and therefore it cannot be exigible to GST also. A similar judgment is there of the Honorable Allahabad High Court also, which said that since business is not goods, so even though along with the sale of the business, there is some transfer of the stock in trade also, but since separate assessment of the value of the stock cannot be ascertained in a lump sum transaction of a sale of business, so therefore you cannot separate the value of the stock from the sale of the business and levy tax on the stock portion of it. So it was held that sale of business is not goods, so therefore it cannot be exigible to tax. Now, another issue which may arise is that in the GST era, since goods and services are both covered within the purview of the goods and services tax, and the definition of service says that whatever is not goods is service. So one may argue that the sale of business, okay, fine, there are judgment which says that it is not goods, but can it not be said that it is sale of service? Now there are no judgments on that aspect, and one may argue this way or that way, but fortunately in the GST, even if it is considered as a service, it says that there is an entry 2 of the notification 12/2017, which grants an exemption in respect of transfer of a going concern as a whole or independent part thereof. So if a transfer of a unit or an undertaking takes place as a going concern, then the GST itself grants exemption to it, even if it is considered as service. So one aspect is that transfer of business as a whole is not goods in the first place, so the question of levy of tax does not arise at all. But suppose if it is considered as a service, even then, if it is a transfer as a going concern, then it is exempted from the purview of levy of GST. Now one may ask as to what is the meaning of the transfer as a going concern. Now on these aspects, there have been judgments of the various high court in different contexts within the purview of different laws. So I'm going to discuss some of those judgments. In one of the Bombay High Court judgment, it was held that in order to characterize a business as a going concern, it is necessary that at the time of the transfer, it must be a running business. And how do you determine whether it is a running business? One of the tests, one of the tests to determine is whether assignee or the transferee is in a position to carry on the business which was being carried on previously. So one may look into whether there is a stock in trade, because if you have to carry on the business as it was being carried on by your previous owner, there must be trading, stock in trade, there must be plant and machinery which must be in existent, they must be operational. So all those aspects combined together, one may determine whether it is a going concern or not. So obviously it will depend from the facts of a case. One has to look into whether the plant and machinery are functional, whether the stock in trade is there, and whether the business can be carried on as it was being carried on by the previous owner. Now, another aspect which was covered by the Delhi High Court is that it is essential that whether the plant and machinery and the manpower. So one of the additional criteria which was added by the Delhi High Court, that whether the plant and machinery and the manpower, without which it would not be possible to continue it is an independent unit are transferred to the demerged company. So those aspects also one may look into that the people, those were main whether key management or the operational staff, they are also transferred along with the unit or not. Now, Supreme Court in another aspect laid down another criteria to determine whether a transfer is a going concern or not by stating that one must check whether there is a transfer of liability also. Because assets are transferred, but if the liability is not transferred, then it cannot be said that the company has been sold off as a going concern. So along with the asset of the company, the liability also must be transferred. But the Delhi High Court distinguished this particular judgment in a subsequent judgment of 2016 and said that suppose some assets or properties are left out, which can cause inconvenience to or trouble to the buying party, then one may exclude it and still it can be held or said that it is transferred as a going concern. So it is not necessary that each and every assets and liabilities are transferred. Some of it, suppose some machinery has become obsolete and the buyer chooses not to buy it and the seller takes it out and dispose it himself. Or suppose some part of the liability, which suppose it has been taken at a very high rate of interest and the buyer says that I am not going to take it over. So there can be some adjustment, but suppose the major assets which are necessary to continue it as a going concern or the major liabilities are not taken over, then it will not be possible to consider it as a going concern. Now, similar judgment of Karnataka High Court is there. Then one may retain certain liabilities while transferring the business. Then another judgment in this context is of Bombay High Court, which said that even if there is a sale of assets and liabilities as a whole and at a lump sum amount, but suppose in order to just for the accounting purpose, the values are assigned to land or building, it will not make it outside the definition of the slum sale. So it may be only accounting exercise to identify the value, but if it is sold as a lump sum, then it will be considered as a sale of business. If the items are not sold item by item. So if there is no itemized sale and the sale of business as a whole is being done, then it will still be considered as a sale of business, even though separate values are assigned. Now, another issue which I wanted to discuss, which is going to create some sort of litigation in the time to come and which is essential for us to understand, is what happens to the free supply by the contracting. We know that in various major contracts, whether it is a government contract or whether it is a construction or installation of or say execution of big projects of say installation of plant and machinery, often it happens that some of the items which are items of high value and wherein the contractee wishes to have some control over the quality of the material supplied, they supplied free of cost to the contractor. Then the question arises, and this question has arose in the past in the context of the sale tax era, whether such free supply will be liable to tax or not. So it was held by the Honorable Supreme Court in the context of the Sale Tax Act that suppose one has entered into a composite contract for supply of labor as well as material. And the buyer or the contractee, in order to have a control over the quality of the material, supplies the goods free of cost to the contractor, and the contractor raises a invoice of labor plus material, and while making payment to the contractor deducts the value of the material supplied free of cost. In such a scenario, it was held that there will be a transfer of property of the goods and therefore to the contractor, and therefore the value of material which is supplied free of cost by the contractee to the contractor will be considered to be against the consideration of the supply of the service of the labor. So it is a kind of a barter where the laborer is giving the supply of the labor, and in such a scenario, it will be levied to GST, sales tax. So in the GST also, if suppose a composite contract is entered into where the responsibility of supply of material is of the contractor, but eventually the contractor chooses to supply it free of cost to the contractor in order to ensure or to have control of the quality or the uninterrupted work, and the value of such material supplied free of cost is deducted from the invoice of the contractor, then it will be chargeable to GST. At both the ends, the contractor will also levy GST, which will be admissible as input tax credit to the contractor, and contractor will also include the value of material in his invoice and levy or paid GST. Now, the other important facet of the definition of supply, as I was discussing, is the meaning of the term business. Because it is essential that the supply or the sale, barter, exchange of the goods must be incidental or in the course or furtherance of the business. So what is the meaning of the term business in the first place? The business is defined in section 2, subsection 17 of the GST Act, which says that any trade, commerce, manufacture, profession, vocation, adventure, wager, or any other similar activity, whether or not it is for a pecuniary benefit, is business. Then it says that any activity or transaction in connection with or incidental to above, that is, any activity is incidental or ancillary to trade, commerce, manufacture, profession, vocation, etc., is also an activity of business. Then thirdly, it says that it is immaterial whether there is a volume, frequency, continuity, or regularity of such transaction. Now I will discuss the various issues which has arose in the past, in the erstwhile era, in the context of such a definition of business. Now, the first issue which I would like to discuss is that what happens if the activity is charitable in nature, but there is a sale and purchase taking place from such charitable, in the course of such charitable activity, then whether such a charitable activity can be considered to be a business. For example, there was a dispute which arose between the Sale Tax Authority and the Sai Publication Fund, which was a charitable organization, and the main objective of the existence of this particular organization or the trust was to spread the message of the Saint Sai Baba. This particular trust was not formed for the purpose of business, but in the course of spreading the message of the Saint Sai Baba, the particular trust was selling literature, books, and other materials So the question arose whether this sale of the literature and the books can be considered to be a business and whether it can be accessible to sales tax. So it was held by the Honorable Supreme Court that the sale of the material or the books or the literature for the purpose of the spreading of the message of the Sai Baba is incidental or ancillary to the such an activity, and therefore it cannot be considered to be a business. So if your main activity is not business in the first place, then even if suppose some sale or transfer or barter or exchange is taking place in the course of such activity, which is the ancillary activity to such a activity, then it cannot be considered to be a business. So therefore it cannot be liable to GST. Now we will discuss the various issues relating to business or the various activities. One such activity is education. Honorable Supreme Court has held in the past that it cannot be said that the distinct objective and the purpose of the education is trade or business or calling or service. Even though this judgment was in the context of the Industrial Dispute Act, and recently there is a very recent judgment of the Honorable Supreme Court also, 2022, November 2022 judgment, wherein the dispute arose between the Narayana Medical College and the state of Andhra Pradesh. And the Honorable Supreme Court says that the education is not business to earn profit, and tuition fees shall always be affordable. Now, in this background, we may analyze and see whether the various activity. Now, we all know that there are various private colleges, there are various private institutions, even schools, which imparts education. But now the education has become a full-fledged business. There are many who, even though have incorporated in the form of a trust, but they charge hefty fees, and it appears that the entire activity is with a profit motive. So the question arises that whether it will be or whether it should be chargeable to tax levy of GST or not. Now, in this context, fortunately, we have now the education is not defined in the CGST Act. So first of all, I think it would be safe to rely upon the meaning assigned to the activity of education per se in different contexts as has been held by the Supreme Court. Now, whether it is with the profit motive or not, I believe that it cannot be looked into if education is not considered as education cannot in the first place satisfy the definition of the business itself, which is trade, commerce, manufacture, profession, vocation, adventure, wager, or any other similar activity. So if the education cannot be considered to be falling within the purview of any of these activities, that is trade, commerce, manufacture, profession, vocation, or adventure, then it goes out of the purview of the definition of business itself, and therefore it goes out of the purview of the GST also. But having said that, the GST Act, even though if it has not defined the word education, but it makes a distinction between the education which is the core education and the education which is non-core education. So there is a exemption notification 11/2017, which grants exemption to certain educational activity. For example, services provided by educational institution to its student, faculty, and staff is exempt. Then transportation of student, faculty, and staff is exempt. Further, catering, including any midday meals scheme sponsored by the central government, state government, is exempt. Then security or cleaning or housekeeping services performed in such educational institution is exempt. Services relating to admission or conduct of examination is exempt. Now, all these things are exempt provided it is a services provided by educational institution. Now the question arises as to what is the meaning of educational institution. Now educational institution has been defined to be services by way of pre-school education and education up to higher secondary school, education as a part of the curriculum for obtaining a qualification recognized by law, and education as a part of an approved vocational education course. So if it is a pre-education or education up to higher secondary school, then irrespective of what kind of fees is being charged by a school, it is exempt. Secondly, if it is an education as a part of a curriculum for obtaining a qualification recognized by law, then also it is exempt. So now being recognized by law means it should be, suppose, a degree, it should lead to be a degree or diploma recognized by law. But many of these private institutes which grant some sort of a diploma without any approval of law, or the training given in a private coaching institutes, they will not consider to be education within the purview of the educational institution, and therefore the services provided by such private coaching institutes or those institutions which are not providing a degree or diploma recognized by law, they will, as per the GST Act, this particular notification, it will not be exempt. But having said that, one may stretch the meaning of the education beyond the purview of what this exemption notification says. And if one relies upon the manner in which the term education is defined by the various high courts, then one may try to counter the argument of the department that education, if it is not recognized by law, or education, if it is not leading to a degree or diploma, would not be part, would be within the purview of the definition of the supply. Because one may very well argue that since the education does not satisfy the definition of the business itself, and irrespective of the fact whether such education is leading to a degree or diploma, but if it can satisfy the very purpose and objective of the definition of the education, then it should fall outside the purview of the definition of business itself. Now, there have been various judgments in the various contexts. For example, it has been held that IIT is not a dealer as its principal activity is academic. Then Institute of Chartered Accountant of India was held to be with the purpose of regulating chartered accountancy, and therefore it was held that the conducting extensive educational programs, coaching, classes, campus placement, etc. cannot be considered as a business, and therefore it cannot be considered to be carrying on any business, trade, or commerce. Then sale of publication by university is not a business. Then it has been held that the charitable organization running medical store and selling medicine cannot be said to be for the purpose of business, and therefore cannot be said to be liable to GST. Now, one may look at it from other angle also. For example, one may argue that suppose I am in the business of trading of a particular item, for example, say oil. And incidentally, it so happened that I sell some scrap material or the other some material at a cost price or less than cost price, whether it can be said to be active within the course or furtherance of business, or whether it can be considered to be liable to GST. Now, in this context, there have been judgment of the Supreme Court which says that if the scrap material or any other item is sold by a business entity, then it will be said to be an activity incidental to carrying on the business, and therefore it will fall within the purview of the definition of business and liable to sales tax. Now, one of the area which I believe is very important from the planning perspective is the works contract. Now, works contract, as we understood in the erstwhile era, wherein the works contract was defined as a transaction which was a combined or composite transaction. So if there was a composite transaction of supply of goods as well as services, then it was considered to be works contract. Now, in the erstwhile era, the service part of it got taxed under the service tax, and the sale of goods part of it got taxed under the VAT Act or the Central Sales Tax Act. Now, under the GST, to make the life easier, now the definition of the works contract is restricted to those type of contracts which are composite contracts for supply of labor as well as material. But those contracts will be only those contracts will be considered as work contract where the activity is in relation to immovable property. So if a works contract is there in the context of a movable property, then it will not be a works contract. For example, suppose an installation of machinery takes place, and that machinery which is being installed does not result into a permanent structure. It cannot be considered as a immovable property. Then it will not fall within the purview of the works contract because it is not leading to immovable property. As I discussed earlier, as to whether what is goods, and in that context, we just discussed a judgment that if you are installing a machinery and it is permanently embedded to earth and it cannot be dismantled without substantial damage, only then it can be said to be immovable property. But if suppose it is installed through a nut bolt system and it can be easily dismantled and removed and installed in some other place, then it will be considered as a movable property. So while trying to understand whether a composite transaction is a goods or whether it is a works contract or not, it is very much essential to understand that jurisprudence and apply to any transaction. Now, works contract is chargeable to 18% of tax because works contract is deemed to be a service. You see, there is a schedule 2 to GST Act which deems some transaction either as a sale of goods or sale of service in order to find out what is the rate of tax applicable to such a transaction. So, with respect to works contract, it is deemed to be a service, and works contract is generally leviable to 18% of tax. Now, if the plant or machinery or the material involved in the execution of works contract are more than 18%, then one would be very happy to get it classified as a works contract. For example, if suppose somebody is installing or constructing a factory wherein the major raw material is say cement and the steel, and cement is say chargeable to tax at the rate of 28%. So if it gets classified as a works contract and if it results into say immovable property, then one would be very happy to get it classified as a works contract. But suppose there is a transaction wherein suppose the rate of tax is less, the item is such that the rate of tax on the plant and machinery being supplied is less than 18%. For example, say solar equipments. Now on the solar equipment, the rate of tax is less than 18%. So if you are, suppose you are constructing a solar plant, which results into immovable property, then if it gets classified as a works contract, then the rate of tax which you have to eventually pay will be more than the rate of tax which is applicable on the supply of solar equipment. So in such a scenario, what should one do? In such a scenario, one should take advantage of the judgments in the erstwhile era, which has held that if you enter into two separate contracts, then they will be treated separately and they will be exigible to tax as a separate contracts. But only if there is a composite contract, they will be treated as a works contract. So if suppose you have a transaction in hand wherein the rate of tax on the items being supplied is rate less than 18%, then it is advisable to enter into two separate contracts, one for sale of material, another for sale of labor. Now the sale of material, suppose the solar equipment, the rate of tax is 5%. So you end up paying only 5% rate of tax. Whereas on the installation part of which only comprises of the labor part, you pay 18% tax. So one can very well structure agreements like that, or one can even enter into agreement whereby you see the items which are attracting less rate of tax, they are excluded separately, and those items which are having more rate of tax, say 28%, say supply of cement, they are categorized in the installation contract, and you get the benefit of 18% rate of tax. So therefore, I was saying that it is very much essential to know the jurisprudence in the erstwhile era, not only to handle litigation, but also to structure your transaction or plan your transaction in such a way that you don't evade the tax, but at the same time get benefited by suitable planning. Now in this slide, there are judgments again, which defines as to in what scenario a plant and machinery will be considered as a movable or immovable goods. Now the another area of litigation or the dispute within the purview of the definition of supply is going to be an item which is considered as a supply in Schedule 2 of the GST Act. It says that the agreeing to the obligation to refrain from an act or to tolerate an act or a situation or to do an act is a service. So if you agree to refrain from an act, you agree that you will not do such a thing, or you tolerate an act or a situation, then it is considered to be deemed to be service, and it is liable to GST within entry 5E of the Schedule 2 of the GST Act. Similar activity was considered as a declared service within section 66E of the Finance Act. Now there are various judgments and the various disputes which arose within the scope of the definition of this particular toleration of an act or refraining from an act. So I'm going to discuss some of the scenarios. For example, amount collected by a appellant by encashment of a bank guarantee was said to be not tolerating an act and therefore cannot be considered to be service. Similarly, in one of the very recent judgment of the Kolkata Tribunal, it has been held that surrendering of tenancy right cannot be considered as an obligation to refrain or tolerate an act and taxed as a declared services. Now, the another issue which frequently arises in commercial transaction is that invariably the transaction or the contracts are structured in such a manner that if either party defaults in compliance of the conditions of the contract, then they are supposed to pay some sort of a penalty or liquidated damage or compensation to the other party who suffers due to the violation of the terms of the act. And even if suppose the contract is cancelled unilaterally by either party, then the either party may be entitled to compensate the other party. So what happens to this compensation or liquidated damages? Whether they can be considered to be obligation to tolerate an act. So in this context, there have been various judgments of the tribunal which has held that amount recovered as a liquidated damages cannot be said to be towards provision of any service, as nobody is going to tolerate the non-compliance of the terms of an agreement. Such a clause is inserted into the agreement in order to prohibit the other side to not to default. The purpose is not to tolerate such a act, and therefore such liquidated damage or compensation etc cannot be said to be toleration on act, and therefore they cannot be chargeable to tax. As of now, in the GST context, there has not been any judgment, but there have been number of judgments in the context of the Service Tax Act, and which can be very useful for us if any such dispute arises in the context of GST Act, which I am very sure are going to arise. Yes, Vikasji.
Yeah, just close this
Hello.
PPT. Just close the PPT.
Yes.
So we have the participants. We can see if any of the participants wants to ask a question. Otherwise, we have already explained it in an elucidated manner. I was just checking it on the YouTube. There was no question.
Right.
But be that as it may, if somebody has a question, you can answer it later on. And we will take the part 2. Those who have been connected for the first time, they can stay connected with us on the social media, and we'll let you know about the second webinar, part 2 of this series. Thank you, everyone. Stay safe, stay blessed.
Thank you very much, Vikasji.